Today, we are looking at the media coverage of Cape Union Mart's case against anti-Israel protesters following 2 years of their intimidation of shoppers, the retailer, the brand, and the executive chairperson, Philip Kravitz. My guest to discuss this with me is Simone Sulcas, attorney and Cape Union Mart's legal advisor. Simone is also vice chairman of the South African Jewish Board Cape Council. Welcome to Right of Reply. This is our community-based show where we respond to contentious issues in the mainstream media. Let's get into it. Simone, why did you bring about this application?
Thanks, Cherise. Thank you for asking me that question. So I just want to first make the point that this was an application that we really did not want to bring. Neither the Cape Union Mart group, nor Philip Kravitz in his personal capacity. And it was one that we ended up having to bring because every other measure that we had taken, every other reasonable measure that we'd taken to curtail the protests and make sure that there weren't any defamatory statements about Cape Union Mart or Philip Kravitz, neither of these measures or any of the measures that we took, the reasonable measures that we took, landed, and they fell on deaf ears, and we were unable to ensure that the protests continued lawfully and to make sure that untruths weren't being used under the guise of freedom of expression.
Correct. That's not the way you would get the case if you looked at how it has been reported in the media. What has and how has it been reported in the media?
So, Cherise, this is definitely more your field than mine. However, I've had a quick crash course in the way that the media would perpetuate the story, and it's been an interesting journey. So we have filed our founding affidavit and our notice of motion, as you know, and this was reported quite extensively in the media, and we were able at this point to tell our side of the story, so to speak. And obviously, a good journalist or a good reporter will always try and be balanced, and that's all we can really hope for. And what really happened was once our affidavits were made public, because most court documents are public, then the media picked up on this. It was a story, and rightly so, they went to the respondents for their angle. So we got our point across as dominus litis, which in Latin means we're the instigators of the action. And they got to make their points as well. So I must tell you that having worked around all of this type of stuff for a couple of years now, I'm not unhappy with the way that the media has come across regarding once we'd launched our action. Once it was in the public domain, we did get the media did respond and they did ask for the other side, and that's fair comment. However, the real challenge is going to be once the respondents file their opposing papers. That's when they get to tell their side of the story. And I can only hope that we get the fair comment and the ability to respond to them the way in which they were afforded that. So we'll see how that plays out. Just want to add in one last little point. I know this is a very long sentence, but I want to add in one little point that I'm talking about main media here. I'm talking about your News 24s. I'm talking about even Ground Up, Daily Maverick, etc. I'm not talking about that other whole area of social media. That's another discussion on its own.
Absolutely. And in terms of mainstream media, so much of the media attention was on the protests. And it kind of can get easily distorted that this is about freedom of expression. What actually do you want to get out of this case, Simone?
So, first of all, there is not anybody in our company, in our legal team, in our PR that has any quarrel with freedom of expression or the freedom to protest. Those are sacrosanct rights that are guaranteed by our Constitution. And this case is actually not about the Constitution, funnily enough. In our papers, you can read them. It specifically says, and we've said it in every single statement that we've ever made, people have the right to protest. People have the right to express themselves freely. What is not allowed is for example, when the protest becomes unlawful, when there is intimidation, when there is harassment, when there are, customers that can't go into stores because there's a banner blocking the store entrance. That no longer becomes a lawful protest. That falls into an unlawful protest. And that is what we are seeking to limit, is the unlawfulness of the protest. Regarding freedom of expression, you absolutely have the right to express yourself freely. Imagine we lived in a country or in a society, and there are others out there, where you cannot express yourself freely. Absolutely. But there again, there are limits to this. One of the limits is defamation. Defaming someone in a way that impugns their fama, which means their reputation. If you call me a thief publicly and I'm not a thief, that is per se defamatory. If you call me a horrible person publicly, that's your opinion. That's not defamatory. So there's a line on defamation, and there's also a line when it comes to hate speech, which we all know all too well. And that is exactly where the Constitution works with the Equality Act and says, yes, absolutely freedom of expression. But when it rolls into hate speech, which propagates hate and incites harm, is not merely hurtful, then we've got case law like the Masuku case, like Kwalani, like a case that we brought recently in the Cape Town court against Thomas Tor, where the court unambiguously said there is a line between freedom of expression and hate speech. So there are limits, and all we're doing in our application, back to your question, is to just make sure that people act in terms of the Constitution and in terms of the law.
Simone, my last question to you: where is the case at the moment? Where is it standing?
So we brought an application. It's on application as opposed to a trial or a court action. And we were in court on the 5th of August. And we asked the court, in legal terms, it's called the relief that you seek or your prayers. And we asked the court for, let's say, 8 points. And that was in our papers. When we arrived in court, the respondents, together with our attorneys, our legal teams, sat together or negotiated together, and by agreement, they agreed to 3 of, let's say, it might be more than 8. I'm just saying 8 points. They agreed to 3, and that was made an order of court. What that means is it operates as a temporary interdict, pending the finalization of the other, let's say, 5 or 6 points in February. The interdict says 3 important things. They cannot harass customers, they cannot intimidate customers, and they cannot obstruct entrance into Cape Union Mart stores. They did, however, make a note in their agreement, which was ordered by the judge president. They did make a note to say that they do not believe that their respondents are in any event breaching any of these, but of course they will agree to them. The rest of the matter will be held over until February, when we will hopefully conclude things. And if you ask me, were we happy with the results so far? We are tentatively satisfied with that result, and I'm glad it came about through agreement, as lawyers, often do on the steps of court. And the judge then made that an order, and I think the hard work continues.
It's a great outcome for those wishing to go and support Cape Union Mart. Please do so. you have your right to support that shock. So thank you. Thank you so much, Simone, for providing that clarification.
Thanks, Cherise. I hope I answered all your questions.